Okay, well, we might get started. Hello and welcome. My name is Tess Hardy. For those who don't know me, I'm the director of the Centre for Employment and Labour Relations Law, and it's my great pleasure to chair today's seminar, which is titled The Adjudication of Collective Rights, the Right to Strike Before the International Court of Justice. So obviously there's been a massive development in the international space, and I'm really pleased that we've got world-leading experts joining us today in Jeffrey Vogt and Amanda Threlfall. So thank you. Before we formally commence, I'd like to acknowledge that I'm holding this event, or we're hosting this event on the unceded lands of the Wurundjeri Wurrung people of the Kulin Nation, and I pay my respects to elders past and present, and acknowledge the importance of Indigenous knowledge in the Academy. So as a community of researchers, teachers, professional staff and students, we're privileged to work and learn every day with Indigenous colleagues and partners. So in this timely webinar, I was lining Jeff up before the advisory opinion had even been handed down. I was hoping that he could join us, and Jeff will provide his insights into the key elements of the ICJ's advisory opinion, and this will be followed by some reflections from Amanda Threlfall, who will discuss the implications for the position in Australia. So we're going to hope to have some time left over for Q&A towards the end of the webinar. So if you do have questions, please post them in the Q&A tab on your screen. This will be recorded and will be available through the Centre's website. So please feel free to access that recording, and please sign up to the Centre's LinkedIn page to keep abreast of future webinars and seminars that we'll be holding through the year. Before we get started, I just want to briefly introduce our speakers. So Jeffrey Vogt is the Rule of Law Director of the Solidarity Centre and co-founder and president of the International Lawyers Assisting Workers, the ILO network. In 2022, he was appointed to the ILO's Governing Body and the ILO Committee on Freedom of Association from 2011 through to 2016. He was legal director of the International Trade Union Confederation, where he coordinated the legal advocacy before the ILO and other international institutions. And before that, he served as the AFL CIO, not the Football League, the Deputy Director of the International Department as its Global Economic Policy Specialist. He has published extensively on international labour law, including a forthcoming book titled The Right to Strike Reimagined, which will be published by Hart this year. And he's testified before executive, legislative and judicial bodies around the world. So pleased to have you join us, Jeff. Really appreciate you staying up for this webinar. And Amanda Threlfall, thank you so much also for sharing your insights. So Amanda is Assistant Secretary of Victorian Trades Hall Council, the peak body of trade unions in Victoria. As Assistant Secretary, Amanda directs strategy and campaigns across a breadth of industrial issues. She previously worked as Senior Advisor to Tim Pallas, who was then Victorian Treasurer and Minister for Industrial Relations. And Amanda worked on reforms to wage theft laws and gig economy laws. So she's worked as a lawyer and industrial officer in a range of different unions, including the Victorian branch of the Australian Education Union. She's also interned with Jeff at the International Trade Union Confederation in Brussels. So thank you both again, and I'll hand over to Jeff.
Great. Thank you, Tess. Thank you for the invitation. Thank you to the Law School of Melbourne and those who are sponsoring this event. So I'm just going to very quickly tell you about this decision from the International Court of Justice. It's not often that the ICJ is called upon to render decisions on labor law. And it's the first one from the ICJ, the Permanent Court of International Justice, which preceded the UN had a number of ILO decisions, but it's been a good 80 years since the last one. So I'm going to find my PowerPoint and put it up here and get us going. All right. So how does a case having to do with the right to strike get before the Hague? In 2012, which was the first year I was the legal advisor for the I2C at this International Labor Conference. Um, the employers group at at the conference declares that it's withdrawing acceptance of the right to strike uh, as a principle protected at the International Labor Organization and specifically under Convention 87. So, for those who are not ILO nerds, the ILO is a tripartite organization. It is represented by governments, employers, and worker organizations. And that the governance of the ILO is done by these three groups. And in 2012, the oversight committee called the Committee on the Application of Standards um, was is called upon to examine 24, 25 cases having to do with um, the extent to which a state has or has not given effect to conventions that it has ratified. And that year in 2012, the employers came to the workers group saying that they would not discuss any cases concerning Convention 87 that had to do with the right to strike because, in their view, it was not protected. Um, so from that moment began a crisis within the supervisory system. Although in the past the employers had some complaints about the extent to which they believe that the ILO supervisory system had overreached on the scope of the right to strike. In 2012 was the first time they took the position um, forcefully that there was no right to strike whatsoever under the convention. Um, in 2014 was the first attempt to try to get this referred to the International Court of Justice under the ILO Constitution. Disputes over the interpretation of a convention can be referred to the ICJ for an advisory opinion. Um, and in 2014, after a couple of years of impasse, there was an effort to try to get it referred at that point. Um, Although the workers were committed to this strategy, we could not convince enough governments at that time that the ICJ was the way to go. Again, it's rare that a case comes up from the ILO to the ICJ. I think many governments at that time wanted to give this dispute more time to see if it could be resolved in-house and through dialogue. Um, but by November of 2023, there was a recognition that 11 years later, the dialogue didn't result in a dispute, given that one group believed that there was no right to strike and the other believed that it's the right to strike is fundamental to the right to freedom of association. There wasn't a lot of middle ground. Um, so at this point, a large number of governments and the workers group together had enough votes to in the governing body to send it to the ICJ for an advisory opinion. So over the course of 2024 and 2025, the written submissions were sent, and oral proceedings took place in October of 2025. Um, and on May 21st of this year, the ICJ delivered its advisory opinion with a 10-4 ruling finding that the right to strike is in fact protected by the convention. Um, So literally, they find the right to strike of workers and their organizations is protected under Convention 87. This is important in that it is an authoritative judicial determination on this issue. Um, the and of course at the ICJ, there's no further appeals. This is the last word on the issue. And the ILO has taken the position that because the Constitution of the ILO refers to a an advisory opinion from the court being a decision, that it is in fact binding on the organization itself. Um, and I think what is also important, and I'll get into more depth a little bit later, is that not only do they find on this specific question, but it also gives a boost to the internal supervisory system of the ILO in finding that they were, in fact, the the conclusions and observations of these advisory bodies or supervisory bodies are given a very high degree of deference by the court. So the decision really rests on three parts of the Vienna Convention on the Law of Treaties. Um, the first starting point with the Vienna Convention, obviously, is to look at the any treaty, looking at its ordinary meaning in light of its context, its object and purpose. Um, but there are a couple of other areas where the court, I think in very kind of creative ways, looks at other rules of international law, which here they find the Covenant on Economic, Social, and Cultural Rights and the Covenant on Civil and Political Rights to provide such relevant rules and come up with this kind of cross-instrumental reading of the ILO conventions and the covenants. Um, and then on Article 32, which is looking at supplementary means, on the one hand, they dismiss the main argument proffered by the employers group, which was that if you look at the preparatory materials, the travaux préparatoires, that the the parties negotiating at the time in 1947 or 48 um, did not intend the right to strike to be included in Convention 87. The court found that there was the travaux were inconclusive. And on the other hand, they found that the ILO supervisory bodies provided supplementary means of interpretation to support the reading under Article 31, and they ascribe great weight to those pronouncements. So I think overall a very strong reading by the court. So the Article 31 analysis of the court is to look primarily at Article 2, 3, and 10 of Convention 87. Article 2, obviously, is the right to form and join organizations of workers and employers without distinction. Article 3, the convention provides that such organizations have a right to organize their activities and programs without interference from the public authorities. And Article 10, which describes that the purpose of organizations is furthering and defending workers and for employer associations, employer interests. So if you look also at uh, the chapeau of the convention, it also looks at um, the constitutional principles uh, of the organization being around the promotion of social justice and the kind of the broader body of international labor standards. So in reading that workers have a right to form organizations. These organizations are meant to further defend the rights and interests of workers, and that they have the ability to create, organize their activities and programs for the purposes of defending those interests without interference. That one a defensible way to read all that is that among those activities and programs to defend the interests of workers must include a strike. And given that the Convention 87 has language which contains exclusions, namely the ability to exclude police and the military from the coverage of the convention, that had the drafters at the time wanted to exclude any particular aim or category from the convention, they could have done so. Um, so in the end, they find that strike action is, in fact, one of the main activities engaged in and tools used by workers to promote their interests, and thereby ensure the effective exercise of the right to freedom of association. Um, the employers in their submissions had come up with this idea that the activities and programs referred only to the internal activities of the organizations, the setting up its rules and constitutions and so forth, but did not extend to external activities. The court addressed that directly and found no basis for this inside-outside distinction, which has no textual basis in the convention. Another interesting part of the decision is that the court recognizes that there is a linkage between and a kind of conversation happening between Convention 87 and the two covenants under the Universal Declaration of Human Rights. The Covenant on Economic, Social, and Cultural Rights specifically mentions the right to strike, and links it to Convention 87. The Covenant on Civil Political Rights, Article 22, speaks broadly of the right to freedom of association, again, also linking itself back to Convention 87. And for over 25 years, the Human Rights Council has, committee has recognized that the right to strike is protected by the right to freedom of association under the covenant. So you have this broad understanding of the right to freedom of association being a principle which protects the right to strike, and that those who have ratified Convention 87 are almost entirely the same states that have ratified the two covenants. And so you have this decision by the majority of the court that the two covenants, as they relate to freedom of association and specifically to the right to strike, form rules under Article 31, 3C, which are relevant for the interpretation of Convention 87. And some years ago, there was actually a joint decision or joint statement from the committee and the ILO on the existence of the right to strike, which was also picked up in the decision. So an interesting kind of cross-UN conversation. So with regard to the supervisory system of the ILO, it was argued that this could also form part of the subsequent practice of states under Article 31. The court didn't support that, but they also supported the idea that it could be a means of supplemental interpretation to confirm the reading under Article 31. And in doing so, used a deference standard that was articulated in the Diallo case, where the court gave great weight to the views of the Human Rights Committee in its interpretation of another treaty in that case, and found that although the Committee of Experts and the Committee on Freedom of Association are not conventional treaty bodies, they perform a functionally equivalent role within the ILO system and therefore should be given the same standard of deference, which was an important outcome for this case, but also very important for the ILO supervisory system going forward, because in addition to the initial attack on the right to strike in 2012, was a questioning of the competence of the supervisory system to even render views or interpretations of the ILO conventions. Uh, this isn't addressed directly, but given the fact that the ICJ finds that the ILO supervisory system is, due great weight, certainly gives a boost to the authoritative nature of the ILO supervisory system. And they do take note that the Committee of Experts had engaged with the Vienna Convention in finding that the right to strike was protected by Convention 87. Um, the Committee of Experts has since 1959 found that Article 3 protects the right to strike. The Committee on Freedom of Association has done so for nearly as long. And so the challenge to the supervisory body's mandate is also, I think, rejected by this case. Um, as I mentioned at the very beginning, one of the key arguments from the employers group, and really served as the basis for their entire line of argumentation, was that the drafters in 1947 and 48 never intended for the right to strike to be protected or regulated in Convention 87. And there's uh, a lot of really good historical work that is done on this. Janice Balaci has done a lot of the deep dive into the archives. But basically, if you take a look at the records of proceedings for Convention 87, the right to strike really doesn't come up much at all. There was a questionnaire that the ILO sent out to states, which they do in developing all conventions. Um, and the question that did come up in the 47 48 was the question as to whether the right to strike was a right that civil servants could enjoy under the convention. Um, there was some debate on that. It was fairly clear that the states that were speaking up at the time were reluctant to see civil servants have the right to strike. Um, but there was no kind of definitive closing of the book on the broader principle of the right to strike being not being protected under the convention, and the fact that they were talking about an exclusion of one group from a broad principle or right to strike suggests that everybody understood that the right to freedom of association protected the right to strike, but were only really concerned about one group. Um, but in the end, the text of Convention 87 does not specifically refer to the right to strike. We argue that in referring to the right to freedom of association, it was understood both in 1947 48, but going as far back as the ILO Constitution, which also protects the right to freedom of association, that it was understood that the right to freedom of association is a kind of bundle of rights, of which the right to strike is one of those. And so that it was not controversial to assume that in protecting freedom of association, you are also protecting a right to strike. And you see immediately afterwards the first cases on the Committee on Freedom of Association find that the right to strike is protected as a principal freedom of association, and then some years later specifically tie that back to Convention 87 and the Committee of Experts again in 1959, also specifically linking the right to strike to Convention 87. So the court found that the drafting history was inconclusive as to the intention, but um, there was debate again as to whether public officials enjoy the right, but it was not about the right to strike in general. So the silence in the final text does not sustain the affirmative exclusion of the right to strike from the convention. One very interesting declaration, which is a concurring opinion, comes from the U.S. Judge Sarah Cleveland, who argues that in addition to what the majority opinion found, that the right to strike could in fact be considered a principle of customary international law, which was something that we had briefed. Um, uh, wasn't expecting the court to really engage with this seriously, but was very happy to see Judge Cleveland take it up and make the case. Um, there were four dissents, and I'm coming to the end of my presentation here soon. There were four dissents, which I won't go into too much detail. Um, uh, Taking issue with the application of the Vienna Convention by the majority. Um, One, Tomka in particular, taking issue with the court getting a second bite at the apple with regard to the ILO supervisory system, finding that they weren't uh, they didn't meet the bar under 31, but can be brought in through the back door, as he says, under Article 32. Uh, Another judge questions the use of the two covenants in forming a rule of international law for the purposes of um, uh, you know, reading the right to strike into Convention 87. Judge Shui is probably the most pointed dissent and sees the entire project of the majority being an exercise in human rights advocacy rather than treaty interpretation. So, not a unanimous decision, but still 10 to 4 is a very comfortable majority. I'll say there are 15 judges on the court. The 15th was appointed after arguments. That judge was also on our legal team for the workers, and yeah, is now the 15th judge on the court. Um, so just kind of thinking through kind of the practical implications of this, so what can we do with the decision? Obviously, it's going to inform what happens within the ILO. And in November, there will be a discussion in the governing body as to what does this decision mean for the ILO, and what's the path forward on this dispute and on the supervisory system generally. Um, but I think it could be very interesting in the context of domestic litigation. We've seen a number of courts which have interpreted their own either statutory legislation or constitutional protections in light of the supervisory system of the ILO. Famous case in Canada some years ago, a Saskatchewan Federation of Labor case in which the court interprets the Charter of Rights of Canada, which refers to freedom of association, to import the right to strike as a fundamental right protected by the Charter. Um, Similarly, the regional human rights systems can also further develop this. The Inter-American Court of Human Rights and the Commission on Human Rights and the European Court have looked to the ILO supervisory system with regard to freedom of association and the right to strike. This The Inter-American system was kind of already headed in this direction. I think the European Court has had a high water mark on the right to strike protection, and it's somewhat ebbed. So it'll be interesting to see what happens after this case. And also within the broader UN system, I think there will be obviously a stronger foundation for cases on the right to strike. Um, and I guess I'll say the last point, given that I'm out of time, is that what's next now. The question posed to the ICJ was very narrow and intentionally so, to look at, is the right to strike in the abstract protected by Convention 87, and did not want to have the court, which really has no specialization in labor law, to wade into all the modalities of the right to strike, and in particular because it was our view that that is a proper role of the ILO supervisory system and not for the ICJ. So now that we have reestablished that the right exists in the convention, there's obviously going to be, I think, a lot of contestation about what the scope of that is. The ILO in general is quite expansive on its interpretation of the right to strike. Um, so finding that there's a right to sympathy and solidarity strikes, which in some jurisdictions are prohibited. Political and protest strikes. These protest strikes in particular are permitted by the ILO, and where that line will be drawn, I think will be further developed, and I think again we'll probably see employers trying to test the limits, and some governments testing the limits of where that ground is. The ILO has also developed through case law a determination of to what services are essential, and therefore services where strikes could be prohibited or restricted. You also have a number of procedural steps that have been taken up by the ILO supervisory system on notice periods, ballots, these sorts of things. And I think we're also going to see the right to strike in new contexts. Just a couple of days ago, we have a new convention on decent work on in the digital economy. What does the right to strike look like on digital platforms? What does a kind of a mass log off look like? And what does that mean if it's happening by employees or by the self-employed? Which brings in the whole competition law element. So I think there'll be a lot in that space that will also be developed by the supervisory system. Yeah, so I think in closing, this the ICJ decision was a very important chapter closing, but again, a lot of work continues. The right to strike is being contested at the national level around the world. So having the legal and moral clarity of the court's opinion is really important. But that alone is not going to protect workers and unions, and we will have to continue the work of defending and promoting the right to strike in law and practice worldwide. So thank you very much for your attention, and happy to turn it over to Amanda.
Wonderful. Thank you very, very much, Jeff, for sharing your insights and expertise with us. I would like to acknowledge the traditional owners of the land on which we meet. I'm currently at Victorian Trades Hall, which proudly stands on the lands of the Wurundjeri people of the mighty Kulin Nation, and I pay my respects to their elders, past, present, and emerging. Victorian Trades Hall Council acknowledges that this land was stolen, never ceded, and always was and always will be Aboriginal land. And congratulations, Jeff, for all of your work throughout the proceedings before the International Court of Justice. And as this is a University of Melbourne event, and we are talking about the right to strike, it's an important reminder that it was stonemasons going on strike at the University of Melbourne that won us the 8-hour day here in Australia. So, how does this impact us here in Australia? The Hague is far away. Is this really going to make a difference? Well, it will impact us here in Australia. We don't have a right to strike in our constitution, which means our national laws are governed by what's in the international conventions. And Australia ratified Convention 87 in 1973. A limited right to strike was then legislated by the Keating Labor government in 1993. And that was actually done in response to ILO criticism that Australia hadn't protected the right to strike in legislation because we didn't have it in our constitution. And since that time, we've seen more and more restrictions placed on workers being able to take protected industrial action. And that culminated in the work choices legislation, which introduced very technical and onerous requirements on workers and unions to take protected industrial action. And a lot of those restrictions still exist in the Fair Work Act today. So we can't take solidarity and political strikes. And ILO bodies have found that to be inconsistent with Convention 87. Under the Fair Work Act, we have to go through protected action ballots and seek orders from the Fair Work Commission. We have the 30-day use it or lose it rule, and the ILO has consistently found this to be unduly burdensome. And of course, our industrial action is also restricted to bargaining, and there's a small window when workers can take protected industrial action, and that's after the normal expiry date of the enterprise agreement. Under the Fair Work Act, strike action can be terminated or suspended if there's significant damage to the economy. Well, that's the whole point of taking industrial action. So what's new now following the advisory opinion? What's changed? Well, I really liked how Jeff talked about in his presentation that the advisory opinion creates new leverage. And it creates new leverage to challenge national legislation, and that includes here in Australia. The advisory opinion can also be used before Australian courts and tribunals. The International Court of Justice is the principal judicial organ of the United Nations. This is only the second referral in ILO history. Australia was involved throughout the proceedings. The Australian government supported the right to strike during proceedings. The main parties were the International Trade Union Confederation and the International Organisation of Employers. The ACTU is affiliated to the ITUC, so Australian unions and workers were represented throughout the proceedings, and the Australian Chamber of Commerce and Industry is a member of the International Organisation of Employers. Something Tess and I were actually talking about last week is how the advisory opinion might impact on the High Court ESO decision, and whether a similar sort of a decision could be made now in light of the advisory opinion. And in that dispute, ESO obtained an order from the Fair Work Commission against the Australian Workers' Union to stop industrial action. And the High Court held that the AWU was prevented from taking industrial action for the remainder of enterprise bargaining. And that was because there had been contraventions of the Fair Work Commission orders. But those contravention orders were no longer in place, so they ceased to operate. But the High Court held that the AWU was still prevented from taking any further industrial action for the remainder of enterprise bargaining negotiations. So as Jeff talked about in his presentation, the advisory opinion now carries some final weight on whether workers do have that right to strike under Convention 87. We can also expect some increased scrutiny of Australia. There's been 16 ILO complaints against Australia, and many of those complaints were actually brought by unions. But don't forget that ILO has been in this deadlock for the last 14 years, so we can expect to see some increased scrutiny. And the International Trade Union Confederation has just recently this month released its annual Global Rights Index. And in 2026, 87% of countries violate the right to strike. And the ITUC has a ranking between 1 and 5, and with 5 as the most extreme ranking for the violation of the right to strike. And Australia was ranked at number 2 out of 5 because of our technical legal requirements that workers and unions have to go through before taking protected industrial action. And previously, Australia was seen as a country where workers were taking lots of industrial action. Historically, when there's more industrial action, wages increase. And when there's lower levels of industrial action, wages tend to stagnate. So we have seen a bit of an uptick in the last 12 months in Australia with workers taking more industrial action. And that's also because of some of the reforms that have happened in the Secure Jobs Better Pay Act. I also thought it'd be useful to touch on how the advisory opinion is being used by unions in the media. The ACTU issued a media release welcoming the ruling on the right to strike and talked about that they were looking forward to working with the ILO on any follow-up to the advisory opinion. And the ACTU represents unions and workers in Australia on ILO committees. The Finance Sector Union issued a media release also welcoming the ruling and had interviews with union members about the importance of taking the right to strike. The Independent Education Union has done a fair bit of media around their bargaining dispute with Victorian Catholic schools and how the International Court of Justice is now backing the right of workers to take industrial action. The AMWU has talked about publicly in the media around restoring the right to strike and campaigning to remove some of the restrictions around strike action. The Transport Workers Union was also quoted in the Australian Financial Review and talked about how the International Court of Justice advisory ruling is a critical lever for workers taking industrial action. And of course, they referred to their 200 enterprise agreements that will be expiring at the same time and looking at taking implementing an industrial campaign. So what's next for Australia? Well, as Jeff talked about, the court's conclusion does not entail any determination on the content, scope, or conditions for the exercise of the right to strike. So we're going to be watching very closely what happens at the ILO Governing Body meetings. That's going to be really important for those discussions around any limitations or conditions on the right to strike. The annual International Labour Conference has just happened in Geneva. And there'll be more follow-up with the ILO Governing Bodies meetings later this year in November. So thank you very much, Tess, for the opportunity to speak today, and I'll hand back to you. Thank you.
Thanks both. That was fantastic and really interesting perspectives on the ICJ advisory opinion, but also what it means for us in Australia. As Amanda said, we are a long way from The Hague. Just want to thank you again, Amanda and Jeff. That was a fantastic session. And thanks also to the sponsoring firms of the Centre for Employment and Labour Relations Law for their support for holding these types of events. So wonderful. Thank you.
Thank you very much.
Thank you so much.
Bye.
Thank you.